Hello, everyone, and welcome. My name is Kambiz Ranavardi, co-president of ColumbiaDC and a graduate of the School of Engineering and Applied Science. This evening, we are privileged to have Ian Millhiser, senior correspondent at Vox, to talk to us about the agenda, how a Republican Supreme Court is reshaping America. I'm sure many of you have been following the news the past few years, actually. This is the title of Ian's most recent book, published by Columbia Global Reports. I highly encourage everyone to check it out and get it. It's very illuminating and sobering at the same time. The link to the book is provided on our website. So before we start, please allow me to briefly introduce our speaker. Ian is a senior correspondent at Vox, where he focuses on the Supreme Court, the Constitution, and the decline of liberal democracy in the U.S. Before joining Vox, he was a columnist at Think Progress. Among other things, he clerked for Judge Eric L. Clay of the U.S. Court of Appeals for the Sixth Circuit and served as a Teach for America Corps member in the Mississippi Delta. He received a BA in philosophy from Kenyon College and a JD magna cum laude from Duke University, where he served as senior note editor on the Duke Law Journal and was elected to the Order of the Coif. He's the author of Injustices, the Supreme Court's history of comforting the comfortable and afflicting the afflicted. So without further ado, Ian, it's all yours.
All right, thank you so much. I hope everyone can see and hear me okay.
We do.
So I want to start by, I guess, acknowledging the one word that I think stands out in the title of my book, and that is the word Republican. I'm old enough to remember when it was considered very gauche to suggest that the justices might indeed be partisan actors, and it was especially very gauche for a lawyer to suggest a thing. But I guess I will say that something fundamental has changed in the Supreme Court. The Supreme Court has always been a very political body, and has always been a very ideological body. But it hasn't necessarily been a very partisan body. When you go back and you look at the court's history, you look at like the great anti-precedents of the court's history, Dred Scott, Plessy v. Ferguson, which upheld segregation, Lochner v. New York, which basically prevented us from having progressive labor laws for 30 years. There were typically Democratic appointees in the majority and Democratic appointees in the dissent. And what has happened in really the last 11 years, so starting in 2010, Justice Stevens retired. Justice Stevens was a moderate Ford appointee, and he was replaced by Justice Kagan, who was an Obama appointee. And so we had a coherent block of 4 justices who tended to vote in a liberal way in every case, or at least in every contentious case, and they were Democrats. We had a coherent block of 5 conservatives that in the most contentious cases tended to vote together, and they were all Republicans. And this is something that is new in the court's history, and I think is reflexive of something very disturbing, which is that the parties have a pretty good idea what they want out of the Supreme Court. And because Republicans now have a 6-3 majority on the court, it matters that the GOP has a very good idea of what they want out of the court. And so before I get into the specifics of that agenda, I'll say that I started writing this book at the end of a kind of lost decade for Congress. So we're just now coming to the end of this period in 2011, when Republicans took control of the House, denied President Obama a governing majority, until 2020, when the pandemic hit. We had virtually no major legislation pass Congress. And we had the tax bill in 2017, but beyond that, you had occasional fights over whether to shut down the government, and that was pretty much it. A whole lot of not legislating happening. And in the same period, the Supreme Court dismantled our campaign finance law. They hobbled the Voting Rights Act. It weakened the ban on sexual harassment. The court held that religious liberty can be used to overcome the rights of workers. It halted Obama's Clean Power Plan, which was his most ambitious effort to fight climate change. it weakened unions, and then lest you think it was all bad news for liberals, there was also the marriage equality decision. So the court has become the locus of policymaking in the United States. It makes sense that Republicans worked so hard to capture the court because they were capturing the most powerful policymaking body in the United States of America. And I think that mere fact that the court has become powerful should be very frightening, because the court is the one unelected body of government. If you don't like what Congress is doing, you can throw them out. If you don't like what the president is doing, you can try to throw them out, although the Electoral College sometimes interferes with that. But if you don't like what the Supreme Court is doing, you are stuck with them probably until they die, or at least until they retire voluntarily. And so, it's a serious problem. The court has both become so partisan and has become so powerful that it is exercising so much policymaking authority in the absence of a functioning legislative branch. So the name of the book is The Agenda. It's about what I think the court's current majority is going to do with all of its power. The short answer is you're gonna have to buy the book to learn about all of it, but I do want to highlight two areas. First is one that you've probably heard a lot about. The second is an area that's more technical, and though these are two areas that don't seem very interconnected, I promise you at the end I'll bring it back together and explain, why you should view these two areas as related to one another. So the first is voting rights. And this is a very hot issue right now. There's a big fight going on in Texas over whether to pass a bill that would make it significantly harder to vote in Texas. I think most people are probably familiar with the Georgia law, which among other things allows the state Republican Party to take over local election boards. And these are local election boards that have the power to disqualify voters or the power to shut down precincts. So we're seeing a lot of very scary things happening with voting rights. And so first of all, if you're talking about voting rights, you first have to talk about race. And the reason you have to talk about race is because if you look at the polls, Democrats typically win between 80 to 90% of African-American voters in any given election. And they typically win between 60 to 70% of Latinos. And so if you are a state lawmaker in somewhere like, say, Georgia or Texas, and your goal is to make it so that Democrats do not vote, is to prevent Democrats from voting, then you can use race as a proxy in order to identify what are the highly Democratic neighborhoods. And you know, like, okay, if I shut down a bunch of polling precincts in Atlanta, and perhaps I make it a crime to bring people a bottle of water while they're waiting in the 6-hour line that they now need to wait in order to vote in Atlanta, then you can be pretty sure that the people who are going to get fed up and leave those lines because they have to get to work that day are going to be, almost overwhelmingly Democrats. The primary safeguard that the United States uses to prevent this kind of race-based discrimination in voting is the Voting Rights Act. And broadly speaking, the Voting Rights Act has three prongs. Let me try to say that again. The Voting Rights Act has three prongs. There's preclearance. Preclearance says that state and local governments with a history of racist election practices have to pre-clear, that's the term that the law uses. They have to get approval for any new voting laws from officials in Washington, D.C. There's something called the intent test, which basically says that if a law is passed with the intent of discriminating on the basis of race, then that sort of voting law will be struck down. And then there's something called the results test, which is super complicated. If there's any lawyers in the audience who have had to litigate a case under the Gingell standards, you have my condolences. But the short version of what the results test entails is that some laws that have a disproportionate impact on voters of color will also be struck down. And so the Supreme Court in Shelby County v. Holder basically deactivated preclearance. For all intents and purposes, preclearance doesn't really exist anymore. In a case called Abbott v. Perez, they didn't get rid of the intent test, but they said that the burden on a plaintiff alleging racist intent is so high that it's almost impossible to And then there's a third case in front of the court right now called Brnovich, which could potentially take out, or at least, make it so hard to win a case under the results test, that the results test itself becomes meaningless. And if you don't have preclearance, and you don't have the intent test, and you don't have the results test, then you don't have the Voting Rights Act. And you don't have any safeguard against states doing things like saying, oh, there are a lot of Black voters in Atlanta. What if we close down a bunch of precincts in Atlanta? What if we disqualify a bunch of voters in Atlanta? And that way we can be sure that our party wins elections. Now, I will note that the court has some other plans, or at least several members of the court has some other plans to limit voting rights. 4 justices, for example, and the reason why 4 is significant is because the 5th vote for this policy, Justice Barrett, just got there, and she hasn't weighed in on whether she agrees with it yet. So everything here turns on whether Amy Coney Barrett wakes up one morning and decides that she really cares about protecting voting rights. But the court has said that it wants to shift power from like everyone who's involved in the state lawmaking process, and potentially say that state legislatures have the exclusive power to write state voting laws, at least with respect to federal elections. So in the strongest form of this would mean that governors can't veto state election laws. It would mean that state Supreme Courts can't enforce state constitutional protections protecting the right to vote, including anti-gerrymandering provisions. It could mean that commissions in states that have independent redistricting commissions that draw the lines to make sure they aren't gerrymandered, those could be struck down. And in states like Wisconsin and Michigan and Pennsylvania, where you have Democratic governors and in some cases Democratic Supreme Courts, the Republican legislature could be given free rein to draw whatever maps it wants. So we are heading into a cycle. I mean, if you followed the news, I'm sure you're aware of this, where a lot of our safeguards against voter disenfranchisement and sort of backdoor voter disenfranchisement, like gerrymandering, gerrymandering doesn't prevent anyone from voting. It just makes sure that a lot of those votes don't really matter. A lot of those safeguards are being dismantled by the Supreme Court. And the fear here, of course, is that it could make it very difficult for us to continue to have competitive elections in this country where either party stands a fair chance of controlling Congress or the White House. So that's the first area I want to discuss, voting rights. The second area, and whenever I say these next 2 words, I know that people are going to want to go to sleep, but I promise you, like, there's a lot at stake here. So the 2 words that no one wants to hear are administrative law. Administrative law is basically, there's 2 different ways that Congress can set policy. One way it can do it is it can do it directly. It can just say, like, let's say it wants to stop pollution. It can just say, all you power plants out there, you've got to install the following device on your power plant, or else you're breaking the law. And that's great, except the problem with that approach is that if Congress had passed a law like that in the 1970s, then a lot of these power plants might still be using whatever the most current technology was to reduce emissions in the 1970s. And so the law wouldn't be accomplishing something. It might even be counterproductive because it would prevent them from using newer technology. And so the other option for when Congress wants to regulate is it can delegate power to an agency. This is what the Clean Air Act does. This is what administrative law is. So the Clean Air Act says that the EPA for certain power plants has to determine what the best available technology is at any given moment. And then it pushes out regulations which allow, which say to the power plants, okay, this is the new device you have to use. This is the new technology. This is what is current. And the great thing about this way of making law is it's both democratic and it is dynamic. It is democratic because Congress is still setting the policy. It's still elected representatives who say the policy is that everyone has to use the best available technology. The EPA has a primarily technocratic job, but it has a job where it's constantly updating the regulations. And so the law stays dynamic and we don't get locked into the same technology that we were using in the 1970s. And I will tell you, like, I cover the Federalist Society a lot as a journalist. The Federalist Society is the big conservative group that played a big role in picking a lot of Trump's judges. And they hate the idea that agencies have this power more than anything. I mean, for the last several years when I attend their conferences, they are obsessed with dismantling the power of the EPA to regulate the environment, or HHS to make sure that your health plans cover everything that you need them to cover, or making sure that workers have to pay, that employers have to pay adequate overtime pay to workers. They hate the idea that agencies can do this. And the leading proposal to get rid of a lot of this power, to delegate regulatory authority to agencies, comes from Neil Gorsuch. I'll just read something from an opinion that he wrote, technically from a dissenting opinion, although Gorsuch now has 4 votes to make this dissenting opinion the law. He said that a federal law permitting agencies to regulate must be, quote, sufficiently definite and precise to enable Congress, the courts, and the public to ascertain whether Congress's guidance has been followed. Now, I don't know what that means. I don't think that Gorsuch really knows what that means. It's an extraordinarily vague standard. And here's the thing about vague legal standards. If there's a sign up when you're driving down the highway that says speed limit 65, great. You know how fast you can drive if you don't want to be pulled over. So long as you're driving under 65, you're fine. But if the sign says everyone must go a reasonable speed, then ultimately, because that's a vague legal standard, it'll be up to a judge to decide if you are going a reasonable speed, if you are being pulled over. When there's a vague legal standard, those vague standards delegate authority to the judiciary. And so what Gorsuch is doing is he is trying to give the judiciary and ultimately the Supreme Court a veto power over all federal regulations. This has enormous potential consequence. I mean, to give you an idea, there's one case making it up through the courts right now. I think it's going to win. The Affordable Care Act has a provision that says insurers have to cover certain preventive care procedures. And this includes everything from certain vaccinations. I mean, this is part of how we're able, I'll get the COVID vaccination for free. This includes things like vision care for children, or at least vision screenings for children. It includes a lot of cancer screenings, things like pap smears. It includes birth control. It includes a lot, is like 80 different items on this list of stuff that insurers have to cover for free. And there are various sub-agencies and boards within the Department of Health and Human Services which have the power to place new items on the list as, the medical profession determines that, yes, this is an important piece of preventive care that, that belongs on this list that insurers have to control. And there's a case making its way up that 5 justices have already signaled that they are open to, that seeks to strike down this entire provision of the ACA. So all 80 of these items will be gone, potentially no more free vaccines, no more free birth control, no more free pap smears, no more free cancer screenings, no more free nothing. So this is, a big deal that has tremendous implications for the environment, for the public health, for labor law. The Supreme Court could suddenly gain a veto power over lots of things. And so I've been talking for a long time, and it's honestly awkward just talking to a camera. So I'm going to stop in just a second. But I promised that I would bring this back around to voting rights. When Gorsuch calls for such a massive transfer of power from the other branches to his branch, the Supreme Court, he is calling for a transfer of power from the elected branches to an unelected judiciary. And so the goal here, whether you're talking about voting rights, whether you're talking about admin law, when you're talking about many of the other issues I discuss in my book, is to make it so that democracy doesn't matter. It's to make it so that we'll still have elections, people will be elected at times, sometimes even Democrats will be elected. But the idea is that if Democratic presidents can't govern because their agencies are stripped of, much of their regulatory authority, and if the elections can be skewed in one way or another by state election laws, the voters are much more cut out of the process, and we cease to be, to have any kind of meaningful democracy. So the stakes here are very high. I have some thoughts about how to solve this that I'm happy to get into in Q&A, but there are no easy solutions. And I think even, you know, and many of the solutions that are out there would require things like Joe Manchin realizing that he needs to get rid of the filibuster. So with that said, I am eager to hear your questions and also eager to no longer have to talk into a camera. So I will open it up to what y'all have to say.
So my name is Miyako, and I'm the admin for the ColumbiaDC alumni.
Oh, that it's so much better when I'm not talking to just a blank screen. I felt awkward as hell through that whole talk.
Well, I can't represent everybody on the call, but I'm here for you to talk to. So thank you everyone for joining us today. We have a couple questions coming in. Go ahead and use that Q&A box to submit your questions. We have quite a bit of time here. So we have somebody mentioning here that the COVID vaccines are not all free. We are paying for $10 to $20 plus, they say $100 to $200 admin costs.
I have heard, I mean, this is actually very serious. Like there are, I have heard that there are insurance companies that are not being entirely honest in this process. I mean, like, I hope everyone on the call is vaccinated, and I haven't researched this to the point that I can give advice, but I will say that, you know, I went to the vaccination clinic sponsored by my county, and it was free, as it should have been. If your insurance company is charging you, then, like, I don't know if that they are doing something illegal, but they are doing something wrong. You know, and if you haven't been vaccinated and you have the option to go to the clinic run by your state or local government, I recommend doing that.
Okay, so we have, I think, probably one of the popular questions. Can you explain what do you expect to happen to Roe v. Wade?
Oh man, Roe is so doomed. I mean, I think that there's one of two ways that the future of abortion rights could play out. I mean, like, you don't put people like Brett Kavanaugh and Amy Coney Barrett, or Neil Gorsuch for that matter, all three of whom have very clear anti-abortion records on the Supreme Court, if you want cases like Roe to persevere. And so I don't have any doubt that the court is going to dismantle abortion rights. I do have some uncertainty as to how they are going to do it. So one thing that could happen is that the court could be honest. It could just use the words Roe v. Wade is overruled. And, like, you know, if you care about abortion rights, that is not a good outcome, but at least everyone knows what happened. You know, politicians can campaign on what has happened. Voters who are angry that the Supreme Court will know that something bad just happened and can vote accordingly in the future. So, like, the court could be honest. The other way that they could approach it, so the two most recent significant abortion cases to be handed down by the Supreme Court both involve what are sometimes referred to as trap laws. I think it's like targeted, I can't remember what it stands for, but it's something that, it's a term that pro-abortion advocates have come up with to refer to laws that on their face appear to be normal health regulations, or like appear designed to do something other than just make abortion difficult to get for no reason. But really their purpose is just to make abortion difficult to get. You know, so, like, there have been two cases involving what are called admitting privileges provisions, where doctors who perform abortions are required to have admitting privileges at a nearby hospital. Often that's a very difficult credential for a doctor to get. And the reason why is because in some cases, these hospitals will have quotas where they'll say, like, you have to admit a certain number of patients in order to keep your admitting privileges. And abortions are actually really safe and rarely result in complications. So if your practice consists of performing abortions, you're not going to have many patients that need to go to the hospital. So you can't get admitting privileges because there's not complications happening. You know, there was another provision out of Texas that was struck down by the Supreme Court that put very expensive architectural requirements on clinics, like the halls had to be but so wide and so on and so forth. I believe the law required every abortion clinic in Texas to have a full operating suite, which is unnecessary for a lot of reasons. It's unnecessary because many clinics only offer medication abortions where you're just given a pill. There's no surgeries going on anywhere in the clinic. And so why would you need a surgical center if you're not performing surgeries? So the idea behind these laws is to drive up the cost of running an abortion clinic, to make it very difficult to operate an abortion clinic, so they have to shut down. And if the court decides to endorse these sorts of laws, they may never actually say that Roe v. Wade is overruled. Like, we may be living in a world where, yeah, technically you have a right to an abortion, but a state could say that you could only receive an abortion in a building that's made out of solid gold. They can do, you still have a right, you just can't exercise it. And I don't know which way the court is going to go. If I had to guess, I think they're more likely to go in the direction of explicitly overruling Roe v. Wade, because they just took a case which asked the court to say that it is lawful for states to ban pre-viability abortions that occur before the fetus could live outside of the uterus. And that, I mean, that if you allow that, like, I don't know what's left. So that's a long way of saying, I guess, two things. One is that I think the future of abortion rights is pretty grim. But then the second is that when Roe v. Wade is struck down, like, don't necessarily trust the Supreme Court if they tell you that that's not what they did. Like, when I'm covering, and I'm going to try to be honest about what actually happened. I'm sure there's lots of lawyers who are going to be honest about what happened, but like, it's important to just, to realize that they might try to make their decision look very narrow when in fact they're doing something that allows states to ban abortions outright in practice.
All right, well, we've had a lot of questions start to come in here. We've had a couple about adding seats to the Supreme Court. So different parties will call it something different. Some are calling it packing the court, some are expanding it. There's no real limit. Do you think that's, a good thing? Should we go about that? Is that the solution to some of our problems?
So, I mean, I have some very complicated feelings about court packing. So there's a reason why the United States has nuclear weapons. The reason we have nuclear weapons is so we don't have to use them. The idea is that China, Russia, like everyone who might attack us, they know that we're capable of annihilating all life on Earth. And so, like, the idea is, okay, guys, like, if you want to dance, you know what's going to happen, so let's not dance. And I was hoping that the mere threat of court packing would have a similar deterrent value on the Supreme Court. Because when we talk about adding justice to the court, I mean, let's be honest, like, this would destroy the legitimacy of the federal judiciary. Like, if Congress were to add, there's a bill that would add 4 seats to the Supreme Court and give it a Democratic majority. And if that happens, the governor of Texas isn't going to say, well, gosh, I guess there's a Democratic majority now. I've got to follow Roe v. Wade. Sorry, we got to let all these. No, there's going to be massive resistance. And like, do you really want a confrontation where like the governor of Texas sends the state police to shut down a clinic and then President Biden has to send troops? Are we 100% confident that all those troops will follow that order? Like, I mean, I think there are limits to what you can accomplish by adding seats to the Supreme Court. That said, I am so worried about the court's approach to democracy, about them, a lot of the things I discussed before, striking down the Voting Rights Act, enabling gerrymanders, stripping state Supreme Courts of their power to protect voting rights, stripping state governors of their ability to veto voter suppression. I mean, this is scary stuff. And so the only circumstance that I think, like, I think court packing comes at a very high price. I mean, I think that we will throw much of our society into turmoil if we go down that road. And I don't think that that's a price that should never be paid. I think that you pay that price if the court has become such a threat to democracy that the only way to save our ability to have competitive elections is to effectively destroy the current majority's ability to keep undermining our elections. And I am fearful that we're going to cross that line. Like, I mean, I don't think that court packing should be on the table. Like I said, I'd hope that the threat of it would be enough to deter the Supreme Court from doing really crazy things. But I mean, Joe Manchin isn't going to nuke the filibuster. It's not a credible threat right now. And so, I think we might have to launch the missiles. God, I hope we don't.
Well, so what about instead of that, we have a couple of people saying that Obama missed an opportunity to replace RBG during his second term, or maybe that wouldn't have mattered with the Senate under GOP control. And then another person is saying that there are some not so subtle pushes right now on Justice Breyer to retire. So do you think Democrats have learned their lesson from the last time?
Well, the question is whether Stephen Breyer has learned his lesson. I mean, like, Obama didn't have the power to fire RBG. Like, I mean, I think we now know that she made a terrible, terrible mistake by not retiring in 2014 when Obama was president and when Democrats had a majority in the Senate, and when she could have been replaced by someone more similarly minded than Amy Coney Barrett. And I think that Justice Breyer would make a terrible, terrible mistake if he doesn't retire very soon. And that's not just because we have a Democratic president right now. It's because the Senate, I mean, I get into this a little in the book. Part of the reason we're in this mess is because of Senate malapportionment. In the current Senate, it's a 50-50 Senate, but the 50 Democrats represent, I believe it's about 41 million more people than the 50 Republicans. It's because Wyoming, that has virtually no people in it, gets the same number of senators as California, which is 68 times as many people as Wyoming, that we're in this mess where, the Senate only barely resembles the actual will of the people. And so, given that Republicans have such a built-in systemic advantage in the Senate, and Breyer's 82 years old, this is probably the last time in Breyer's lifetime that there will be a Democratic Senate. And if there's a Republican Senate, we already know what's going to happen. We saw what happened to Merrick Garland. Like, Mitch McConnell will just hold the seat open forever if he has to, until a Republican can fill it. And so I hope Breyer realizes that. He's been making a lot of worrisome noises lately about, I mean, there's a whole book I just published a scathing review of it that he wrote, where he's very concerned that the court is appearing too political, and he wants to emphasize that judges follow their oaths and like they don't come there thinking of every case in a partisan sense, and like and he thinks it's very important to like diminish the perception that the court is political, and for that reason he might not want to retire strategically. And I mean, Steve, the reason why people perceive the court as political is because the court is political. Like, I like to make pretend too, but like, I think, I just hope that he decides to live in the actual world, and he recognizes that, for the sake of the things that he believes in, and for the sake of our democracy, that we can't have another Neil Gorsuch or another Brett Kavanaugh in the Supreme Court.
Well, given that you said that the court is political, we had somebody ask, to what extent do you think the court considers political dynamics in landmark cases? Will they possibly avoid overly contentious rulings to stall momentum towards court packing?
I think it depends on the justice. I mean, I don't know if there's anyone on the court right now who's specifically worried about court packing and is thinking like, maybe we don't strike down the Voting Rights Act this year. Maybe we wait until Republicans have the Senate. I mean, I don't know if that's going on through any of its head or not. I mean, there was a lot of informed speculation about Chief Justice Roberts. I mean, we know that he initially had voted to strike down much of the Affordable Care Act, and then he changed his mind and only, struck down some of it, only made the Medicaid expansion optional. And so, like, there is a lot of, informed speculation that Roberts in particular is very concerned about, making sure that his court doesn't push too hard, too fast, and, in a way that triggers a backlash to the court. It's not entirely clear that what Roberts thinks matters anymore, because Roberts is no longer the median vote. Brett Kavanaugh is the median vote. And, there have been some very significant decisions, especially in the space of religion and questions like whether or not churches have to follow public health orders intended to protect everyone against COVID-19, where Roberts said, of course they do. And the other 5 Republican appointees, including Kavanaugh, said, no, they don't. So it's not clear to me whether any members of this court think this way. Now, that said, I don't necessarily think, with the possible exception of Justice Alito, that there's any members of this court who are just pure partisans, that that go back to their chambers and rub their wicked hands together and say how can I help my political party achieve its goals? No, I don't think that happens. I think that all of the justices, probably including Alito, are behaving in good faith in the sense that when they reach a decision, they reach the decision that they think that the law requires. But all of these justices had records. 8 of them were lower court judges before they got on the Supreme Court. And, the one exception is Kagan, and everyone knew her because she'd been in the Clinton White House forever. And so all these justices have records. The presidents who nominate them are very familiar with their records. So someone like Neil Gorsuch doesn't have to act in good faith, or doesn't have to act in bad faith. He doesn't have to have a partisan mindset. He's just on one end of the bell curve where he's the guy where completely acting in good faith just thinks that the law happens to produce conservative results all the frickin' time. And there's always going to be someone who's on that end of the bell curve. And if you're the president of the United States and you want to name a conservative justice, you can just look at who the sitting judges are who are on that end of the bell curve. And, similarly, if you're a Democratic president and you want to nominate a liberal justice, you don't have to nominate a hack. You just see okay, well, this person's been there for a while and they keep handing down decisions I like, so I'll nominate them because they're probably going to keep handing down decisions I like. So this is actually one area, and I get into this in my book review of Justice Breyer's book. This is one area where I really disagree with Breyer. Breyer emphasizes in his book, I think all my colleagues act in good faith and they aren't being partisan hacks. And I think I agree with him. But so what? I mean, if you lose your health care because of some stupid Supreme Court decision, do you care that you lost it because the 5 justices in the majority had an ideological commitment to some theory of law that transcends partisanship, or because they were just being hacks? No, you're worried about how you're going to pay for your damn cancer treatment. And so, my point is that I think it's very possible to assemble a court of very ideological justices who aren't engaged in any kind of nefarious reasoning. They just, have been selected because they have a demonstrated record of consistently believing that the law produces results that one party or the other really likes.
Well, we have a comment here that says the Federalist Society has taken, 40-year project to populate the court as it is now. And they've played a really strong ground game at all levels, including in law schools. It goes back to, clerkships and growing their pipeline. And so this person asked, is there a liberal analogy to this for liberals for, potentially facing a 25-year minority in the Supreme Court?
Yeah, there are organizations that are trying to do what the Federalist Society does for conservatives, but for liberals. There's an organization called the American Constitution Society that was formed explicitly to do that. There is a newer group called the People's Parity Project that is doing a lot of things, but one of the things that it's doing is trying to build career pipelines for lawyers where like you could still become a judge even if you didn't go to a big law firm. And so like there are groups that are thinking in these terms. Now that said, like, you know, I mean, I've talked to a lot, I mean, I used to work for ACS. I've talked to a lot of the people who have been in leadership positions there. I've talked to, you know, people who've sat on their board chairs. And one thing that like a former very senior person at ACS told me that has stuck with me. And like, this is, I think, a general problem with American politics. So the Republican Party is an ideological party. And I don't mean that in like the pejorative sense of the word ideological. I mean that like the Republican Party organizes itself and tries, you know, has historically organized itself and like builds its politics around a shared ideology, around a shared sense of like what they want the government to do and not do. I mean, I think that ideology is shifting as it moves from like the ideology of Paul Ryan to like the ideology of whatever Donald Trump's hangers on think. But like, it's a party that organizes itself around a set of beliefs. The Democratic Party is a coalition party. You know, it is made up of various different groups, many of which have coherent ideologies, but they aren't necessarily the same as the other members of that coalition. And so like within the Democratic coalition, you sometimes have conflicts. You know, you have an environmental group that is at odds with a labor union that, you know, maybe wants to build a pipeline that isn't very good for the environment. You know, these sorts of conflicts happen all the time. You have issues that matter a lot to members of the to individual members of the Democratic coalition, but don't necessarily motivate, other members of the Democratic coalition. So like, if I am there because I care most about workers' rights, then like, I'm not necessarily going to oppose my party on abortion, but it doesn't mean that abortion is what gets me up and charged and like ready to go to work every day to fight to elect my party. Like that, you know, and this, I could say the same thing about the people who are charged up because they really care about the abortion issues. That's just how coalitions work. And so the frustration that my friend who was in a very senior leadership position at ACS expressed to me is that at the Federalist Society, you have all these people and they work for these big law firms where they're representing these corporate clients who like are willing to pay them $800 an hour to like try to dismantle the EPA or like, you know, do these things that are ideologically in line with what the Federalist Society wants to do. And then you go to an ACS convention and like, there's always, say, you know, a panel on immigration. And the people who are there because immigration is their issue and that's why they're part of their coalition, like they attend that panel and they may not necessarily like be there to interact with the other people who are, you know, who are from other parts of the coalition. And I'm not singling immigration people out. Like I could say the same thing about people who care about reproductive freedom or workers' rights or, you know, voting rights or whatever. You know, it's just, you're trying to bring a bunch of different people together. And so that's a long wind up to basically say that I think the Federalist Society benefits from the fact that it has an easier task. It is easier to organize people who all have a commonality of ideology and who often are doing work, very lucrative work, that aligns with the ideology of the organization. I mean, there's a lot of people who are big law firm partners at ACS too, and they spend 5-6 days a week undermining the work that ACS is trying to do. And then maybe on Sunday, they'll go to an ACS event. And so, you know, it's just harder to organize that kind of coalition. Now, I think that the rise of Donald Trump, the emergence of, you know, these, you know, the explicit threats to democracy that we're now seeing, those can work really hard to unify a coalition. A common enemy really matters. Or and like there are historical examples of like, coalitions where like the thing that unifies the coalition is just everyone really believes we need to preserve liberal democracy. I don't know that this is quite what just happened in Israel, but what we just saw in Israel was a coalition of people who normally would hate each other decide that they hate Benjamin Netanyahu more. And so they formed a coalition to depose him. And so I don't think that the task of organizing liberals is impossible. I think that groups like ACS and the People's Parity Project and other folks who want to play in this space, they have an easier task than they did 20 years ago. But the reason they have an easy task is because the threats of a very ideological Supreme Court are now very apparent. And I mean, you never want to start a fight when the court has already struck down much of the Voting Rights Act. Like that is not a position of strength to be, to be starting from.
Well, we have a couple of specific questions here, so maybe slightly, hopefully shorter answers.
All right.
So we can get through a couple of these. So the first one is from Jane, and she says, on the Voting Rights Act, do you think that the Congress can pass a revised version that would be narrow enough to survive Supreme Court scrutiny and still be meaningful?
I mean, so here's the problem. The Supreme Court's voting rights decisions are so haphazard. Like the Shelby County decision, the decision striking down preclearance. The argument, like the logic of Shelby County is that there's this doctrine called the equal dignity of the states. And the way that preclearance works, again, is that only states with a history of racist practices were, like, not every state was subject to preclearance, only some states were subject to preclearance. And this doctrine of the equal dignity of the states means that generally Congress needs to treat every state equally. And so since this law doesn't treat every state equally, that makes it suspect. And it no longer has a good enough reason for treating these states in this way. So boom, it has to be struck down. That was the logic of Shelby County. There is no equal dignity clause in the Constitution. Like, you can read the whole document, you won't find any reference to this equal dignity nonsense. It is something that John Roberts made up. It's a judicially created doctrine, and it's not even a judicially created doctrine that anyone had heard of 15 years ago. It is something that John Roberts made up. And so, like, I mean, if a member of Congress wanted my advice on what a voting rights bill should say that is more likely to survive Supreme Court review, I could give them advice. I actually think that a bill is more likely to survive if you want to revive preclearance, if you apply it to all 50 states, which, by the way, is something that Joe Manchin suggested, because then you aren't offending the equal dignity principle, then you're treating every state the same. But, like, if John Roberts could just make up this equal dignity stuff, like, maybe he'll make something else up. And that all sounds pessimistic, and I mean, it is really grim, but, like, I guess if I were a member of Congress, I would find it sort of liberating. Like, if the court had set clear rules that it said you can do this and you can't do this and you can't do that, but you can do this, then I would have to be really careful if I was a member of Congress to make sure that I followed the rules. Because, like, you don't want to step on a landmine that you know is there. But, like, if you got to make it across that field and you have no idea where the landmines are and no one's going to tell you, like, at some point you just got to take a walk. Like, at some point you just have to say, like, okay, we're going to pass the best bill we can, and what you going to do, John Roberts? Because, like, you can't negotiate against someone who isn't going to tell you what their negotiating position is.
Okay, next question is from Nicola, who says, would you be good enough to comment on the likely reaction of the current SCOTUS to Judge Benitez's decision overturning the California ban on assault weapons?
So I hope that the opinion that they eventually write won't be as poorly reasoned as Judge Benitez's decision. I mean, some of you might have seen this was the opinion where, without citation, he claimed that the COVID vaccine has killed more people than assault rifles. And like, first of all, that's not true. Second of all, if you're going to make a claim like that, you really should drop a citation there. And third of all, at least some enterprising folks on Twitter have pointed out that like the one place where this non-fact has been stated is the Tucker Carlson show. So like, I don't know where Judge Benitez got it from, but like, I think that the Supreme Court, the quality of the law clerks are very high, and they will probably draft a decision that doesn't make those sorts of, unforced errors. That said, I mean, there's a case that the court just granted dealing with guns. I mean, dealing with the question of like whether basically anyone can get a concealed carry permit in the state of New York. And I think it's very obvious they took that case because they want to say that virtually anyone can get a concealed carry permit in the state of New York. Judge Kavanaugh, or when he was still Judge Kavanaugh, when he was a lower court judge, wrote an opinion where he said explicitly, yeah, I think assault rifle bans are unconstitutional. The logic to his opinion is in DC v. Heller, which is the seminal case in 2008, which was the first decision in American history saying that the Supreme Court, that the Second Amendment protects an individual right to own firearms. There's a line in there saying that lawmakers may still ban dangerous and unusual weapons. That was the line from Heller. Dangerous, unusual weapons may be banned. And Kavanaugh's argument was, there are just a shit ton of assault rifles in the United States. Like, this isn't an unusual weapon. They're everywhere. And like, I mean, as a factual matter, I don't think he's wrong about that. But like, I mean, I think that's troubling reasoning. I mean, for one reason, it sort of sets up a one-way ratchet where like, if a bunch of people get their hands on like tanks, then I guess they're no longer unusual weapons. And so everyone gets to have a tank. Like, that doesn't strike me as the best way to run a society. But, the question was, what do I think is going to happen? I think the California assault rifles ban is being struck down. And I think that, I mean, barring a significant change of membership on the Supreme Court, both Kavanaugh and Barrett have written opinions as lower court judges saying that they want a much more expansive view of the Second Amendment. And so I don't think, although I'm not sure about this, that the court will strike down literally all gun regulations. I think they will probably allow bans on convicted felons possessing firearms. I think they will probably allow bans on people with serious mental illnesses possessing firearms. But even there, I'm not sure. I mean, Barrett had a decision as a lower court judge where there was someone who had a felony money laundering conviction. And she said, well, that's not a violent crime. Someone who launders money isn't dangerous. So why can't they have a gun? And so, like, I guess Barrett wants us now to have a bunch of litigation over who's so dangerous. I mean, is shoplifting bad enough? Like, what if I got in a fist fight when I was 17 years old? Like, I guess we're going to have to litigate that. And so anyways, the punchline is I think that the future of gun laws is really grim under the Supreme Court.
And one more kind of specific question here. Elliot asks what your view of limitations on speech on public websites, restrictions on who can post or what is posted.
Yeah. So this is mostly not a matter for the Supreme Court. So like the First Amendment applies to the government. And like that's true of most constitutional provisions. Like the only constitutional right that can be enforced against a private individual is the 13th Amendment. The 13th Amendment prohibits everyone from owning slaves. But beyond that, the Constitution only applies to the government. And, I think there's good reasons for that. Like the government has a monopoly on the legitimate use of force. Like if, Twitter doesn't like something that I have to say, they can't send the cops after me. You know, they can't arrest me. So I think that like it makes sense that, you know, we keep a certain amount of perspective here. Like if I'm banned from Facebook, that is different in kind from what the government could do to me if the government had the power to censor my speech. There are federal laws in this space. I mean, you know, the law that everyone keeps talking about is Section 230 of the Communications Decency Act. And what Section 230 of the Communications Decency Act says is essentially that if you run a website where like everyone is allowed to, you know, submit comments or posts, you know, whether it's like Twitter or like actually when the Communications Decency Act was written, the thing that they had in mind in particular was America Online, the little AOL chat rooms where like, say you had a bunch of people who are just really into Dungeons and Dragons, they would go to this room and they'd all chat about Dungeons and Dragons. And like, that was the hot new thing in like 1994. And Congress wanted to make sure that AOL could have these rooms, or, you know, or that things like Twitter could exist, and that they could also be moderated. And the reason why they wanted private website owners to be able to moderate them is they weren't thinking about a situation where like some politician shows up and does something crazy. They were thinking about child porn. Like, you know, there's a reason why this is called the Communications Decency Act. So under the law that existed prior to the Communications Decency Act, if you moderated the content on your site, if you changed what appeared on your website, then you are considered to be a publisher and you could potentially be sued for anything that appears on the site. And so Congress wanted to make sure that if someone posts child porn, the website owner could delete it without being subject to liability. You know, they wanted to deal with things like just abusive behavior. Like, you know, if I show up in an AOL chat room and just start writing racial slurs over and over again, Congress wanted the moderators of that site to be able to kick me off, you know, without having the people subject to liability. And so the Supreme Court's job is to just follow that law. And that means that, you know, Twitter has the right to moderate its page. It can kick Donald Trump off. It can kick anyone else off. Like the Supreme Court really doesn't have a business setting policy here. Congress could change the policy. And I mean, some people have some interesting proposals for how to amend the Communications Decency Act. You know, I mean, you could do things like have more transparency. You require Facebook to disclose its algorithm. You require them to disclose what their particular policy is for when someone gets banned. And like, maybe that's a good idea. I think it's really, really hard to write an amendment to the Communications Decency Act that like draws a line with respect to political speech that doesn't have consequences that you don't like. Like, I mean, if your concern is that like, you know about someone who got kicked off of Twitter because they expressed a fairly innocuous political view and you thought that it was wrong for Twitter to ban them, it's just really hard to draft a statute that doesn't let Twitter do that, but that also lets them kick off the person who's posting child porn. And so like, that's the policy problem that you have to solve. If you think that where Congress drew the line in the Communications Decency Act is wrong, like you have to find a principled way that, you know, still makes it so that, you know, the child pornographer or the simple abuser, or for that matter, the adult pornographer. Like, you know, I mean, if I'm posting pictures of naked 30-year-old people onto the internet, like, you should consent to seeing that before you have to see it. Like, you know, there's plenty of offensive things that people can do online that I think everyone would agree that like Twitter and Facebook should be able to moderate that sort of behavior. And I just think it's very, very hard to draft a law that like draws a different line in a way that we would find sensible.
Okay, we're starting to get some questions in as following up to some of your earlier statements. So I apologize, this is not my field, so I'm going to read this word for word to make sure I say it right for Joseph Gatsworth. He says, a few years before Shelby County, the court upheld it, but told Congress it should update its formula for deciding whether a state or part of a state should be subject to preclearance, but Congress did not change or check the formula. So the question is, would it be possible for Congress to update its formula, which may identify more states for preclearance, but excuse one or two that have improved?
Yeah, you talk about the Namudno decision. So like, the history of Shelby County, I mean, I said that Roberts just made up this equal dignity of the states nonsense, which was true. He didn't actually make it up in the Shelby County decision. What he did was, there was a previous case which asked the court to get rid of preclearance called Namudno. I think it was 2009 that was handed down. And that was the case where the court was like, oh yeah, there's this equal dignity of the state things that we just made up. Congress, you better go fix this law and you better comply with the equal dignity of the states or you're in big trouble, folks. And then Congress didn't do anything. And 4 years later, they struck down preclearance. And so the question is there a way to comply with like this equal dignity principle that still applies to some states and not to others? And I guess my answer to that is maybe. You know, like Shelby County said, what it said specifically was, it said that, first of all, it said there's this doctrine of equal dignity of the state. So generally states have to be treated the same. And then it says if there's like particularly pervasive or flagrant violations like Jim Crow voter suppression, then in that circumstance, there can be a departure from this equal dignity rule. And then it said, but like Congress hasn't gone back and seen whether it's drawn the line in this right place and like subjected the right states to this rule in a long time, and it's been too long, and like you have to make sure that your rule complies with whatever the court considers to be like the current conditions in the states in order to you know, before you can have any kind of preclearance regime that treats states differently. And so the question is, could you come up with a new formula? And the answer is maybe. Like, if the United States had a functioning legislative branch, the way that this could work is that Congress could pass a new voting rights law, and the Supreme Court would look at it, and maybe they'd say yes, maybe they'd say no. And if they said no, they'd write an opinion telling you why they said no. And then the functioning legislative branch could read that opinion and say, okay, they want us to do something else. Let's write a new bill that complies with what the Supreme Court wants us to do. And, you know, maybe they say yes this time. But like, you can have this sort of iterative conversation between the Supreme Court and a functioning legislative branch. But like, the way that the legislative branch actually works is that it does nothing for 10 years. And then, like, you know, except for like passing, you know, taxing and spending bills, because you can do that through reconciliation, but like it does nothing for 10 years. And then you have a big fight over whether to nuke the filibuster. Let's just assume that like Joe Manchin and Kyrsten Sinema get religion tomorrow and like decide to pass a restoration of the Voting Rights Act. So let's say that passes tomorrow, and Congress makes its best guess as to what the Supreme Court is going to allow. So like that law is allowed, and then like realistically, there's going to be like a year and a half, 2 years of litigation over it. And so in 2023, the Supreme Court now tells us whether or not this new Voting Rights Act is constitutional. Maybe they strike it down. And, you know, so maybe that's all right. So maybe they strike it down, and like, then what? I mean, maybe Congress still has a majority that can pass a new try, but like, Democrats are going to have to run in a Senate where like malapportionment gives them a huge disadvantage, and in a House where gerrymandering gives them a huge disadvantage, and like the party that controls the White House historically has not done very well in midterm elections. So like, probably a bill doesn't pass. I mean, like, I think we would be having a very different conversation about the problem of the Supreme Court if we had a functioning legislative branch. you know, because then you could have this iterative process where, like, if the Supreme Court does something bad, fine, Congress can go back and try to fix it. But like, that whole process just doesn't work. I mean, like, there was a case, I guess 6-7 years ago, called King v. Burwell, where someone found, like, was basically a typo in the Affordable Care Act. And they claimed that, like, because of this typo, in like most states, instead of having these insurance markets where like people would get subsidies, instead the law had to be read in a way that would have completely collapsed the individual insurance market in like most of the states in the country. It would have been a train wreck, would have been worse than if there was no Affordable Care Act at all. Like, no one who doesn't have employer insurance or Medicare or something like that would have been able to get insurance. Would have been a complete disaster. And like, eventually, like, the Supreme Court did the right thing in a 6-3 vote. They said, like, yeah, like, there's this really poorly drafted provision, but when you read it in context, it's clear that Congress didn't mean to do the insane thing. And like, there's all these other provisions that don't make sense if we read this one to do the insane thing. So we're not going to read it to do the insane thing. Like, the way that that case would have been handled 20 years ago is like, the lawsuit would have been filed and Congress would have said, oh, that's dumb, we better fix that law. And like, it never would have been a thing. But because we don't have a functioning legislative branch, we now live in a world where like the Supreme Court hands down some vague standard and we get to play like, guess if they're going to allow the new law. And if you guess wrong, then you got to wait 10 years. And, you know, when you write that new law, you better not screw anything up. Because if like, and it's not like it was even a member of Congress who screwed the thing up with King v. Burwell. It was some lawyer in the legislative drafting office that committed malpractice. Like, if some lawyer that no one has ever heard of didn't get enough sleep that night and screws something up, now 20 million people need to lose health care. Like, you know, it's no way to run a country.
Okay, we have a couple more questions about packing the court. So I'll do, this one is from somebody who says that sending in the federal troops, which I think you had mentioned, like if some of the southern states say you can't have abortions, and then would they send in like the National Guard or something? And so this person says sending in federal troops is what it took to ensure desegregation of public schools. So what makes the current states different?
I mean, I just think abortion politics are different. I mean, you know, and I'm pro-choice, but like, I think if you give an order to like a unit or, you know, or to a regiment of enlisted men, and you assume just like, if I look at the polls, and what the polls tell me is that like 25-30% of those men are going to believe that they've been ordered to like allow murders to continue. I mean, I just think the politics of the issue are different. I think that part of the reason we're in this mess, and like, I mean, I want to take it out of the context of abortion because, like, you know, I think reasonable people can disagree on abortion. I don't think reasonable people can disagree, for example, on who won the 2020 election. But we live in a country where like probably 30% of the country believes completely bonkers shit about who won the 2020 election. And some of them tried to violently overthrow the government very recently. And like, you know, I mean, there comes time, there can come times when you have to use military force against your own citizens when you are in charge of a nation. But I just think you should use that power extraordinarily sparingly. And you should be conscious of the fact that when you do it, like, it doesn't always end well.
So our second question on that is, Elliot says the future of our government, as you describe it, an actual subversion of democracy, is so pernicious and prejudicial that it might well provoke violent actions by the minorities that would be deprived of their rights. Is that prospect bad enough that it would justify packing the court?
I mean, my view, and I mean, if you want to read my full view on this, I wrote a piece in Democracy Journal like maybe 4 years ago. I think it's called like Let's Talk About Court Packing. And the argument I make in that point is that the only circumstance where court packing could be justified is when the court becomes an existential threat to democracy. And so, like, if I think we're going to lose our ability to have competitive elections in this country, then, if I was a member of Congress, I would vote yes, and I would not hesitate on the court packing bill. But like, I just, I don't think that's something that should be done frivolously. And I think that if it becomes necessary for Congress to pull the trigger on that tactic, our society is going to pay a heavy price for it.
So I want to give some time here. We have some pushback, which I think was expected. So we have Giannis says, why are you calling the majority of the Supreme Court justices Republicans? He says, isn't that a faux pas? Shouldn't it be more proper if you were to label them by their ideology or as conservatives?
Yeah, I mean, this goes to like part of what I said when I started my talk. Like, part of it is just that, the court is more partisan than it has ever been, in the sense that from like the beginning of like when we had a Supreme Court until 2010, when Justice Stevens retired, like, it just wasn't a thing that there were coherent blocks appointed by Republican presidents and blocks appointed by Democratic presidents. And now there are. But like, I also just think that it's the most honest way to describe the court. I mean, both parties, I think, have grown very sophisticated in identifying judges who will accomplish what their party wants the courts to accomplish. And I think that the Republican Party in particular has a very clear agenda. I mean, read my book to learn all about it. For what they want to accomplish through the judiciary. I don't think that Mitch McConnell blocked Merrick Garland because he thought it was irrelevant which party controls the Supreme Court. I think he did that because he thought it matters a great deal, and because he thought that his party would benefit from controlling the Supreme Court. And so, I mean, I do think that the justices, this goes back to something I said earlier. I think that their internal lives are probably different than the internal life of an elected official. Like, I think that if you're a United States senator, you just get up and you say, well, I think this bill is good and it's good for my party, so I'm going to vote for it. And if you're a judge, you don't necessarily think that way. But again, like, the way that you get to the Supreme Court is that you build a record, and and if that record shows that you are likely to do the thing that the person who is in the White House wants a justice to do, then you get appointed. You get appointed because the president has an agenda and they think that you're going to help that agenda. And yeah, I mean, like, I don't think that, Neil Gorsuch, for example, gets up every morning and says, what can I do to help the Republican Party today? But I think that he's getting up virtually every day, handing down decisions that help the Republican Party.
I know some on the very far left will say that the Democratic Party is really just very centrist and like in opposition to the Republicans, and Republicans are just very ruthless in what they believe in, and they push to get it done, and that Democrats actually work with Republicans to pass laws. I mean, the tax cuts, I think, was fairly Republican, but the two COVID bills that we saw during the Trump administration did have Democratic support, whereas under Biden, it was completely Democratic on the Senate side. So I don't know if you have kind of some opinions on that, on the ruthlessness of the Republicans to do what they believe in and get their views passed.
Yeah, I mean, I think that Republicans, when Donald Trump was in the White House, wanted Donald Trump to remain in the White House. And so they passed a COVID relief bill because they knew if the economy completely tanked, like, presidents do not get reelected in the middle of an economic depression. And like, the reason why they passed the second COVID relief bill in December of last year is because John Ossoff and Raphael Warnock were running on, if you elect me, we'll give you another $1,400. And like, that's it. Like they didn't want Raphael Warnock and John Ossoff to win. And yeah, now that Democrats benefit from the economy being strong, Republicans aren't voting for bills that will benefit the economy anymore. But like, to the point about like Republicans just being more ruthless than Democrats, I read it slightly differently. I mean, I go back to my analysis earlier about how the Democrats are a coalition. Like one of my pet peeves is when I hear someone say, I hate that the Democrats did X, or I hate that the Democrats won't do X, when in fact, Joe Manchin and Kyrsten Sinema won't do X. You know, like I literally was just on the phone with Chuck Schumer's office today. Chuck Schumer really wants to pass a voting rights bill. He really wants to get it done. And like, I believe that like Chuck Schumer will do anything he has to do to get S1 or HR1 or a bill that's similar to it through the Congress if he can. But Chuck Schumer does not have the power to kidnap Kyrsten Sinema and replace her with a look-alike who will vote to get rid of the filibuster. Like, well, that is not
legs. It can't be that hard.
Right. Yeah, you know, I'm like Joe Manchin, or like, you know, Chuck Schumer is, I think, is really annoyed with Joe Manchin right now. But like, okay, now you're annoyed with Joe Manchin. Like, I'm annoyed with Joe Manchin too. I can keep throwing my annoyance in his direction, but like, Joe Manchin is an autonomous person and like has his own agency and unfortunately can do whatever the hell he wants. And like, you know, and it's not always Joe Manchin who's the villain here, but like, it's a coalition party. Like, you know, it goes back to what I said earlier about it's just harder to organize a coalition. I mean, like, one thing that, like, even if you set aside the problem with the filibuster, like, you know, there's been a lot of good reporting, you know, some of it my colleague Andrew Prokop at Vox, about how Democrats are probably less united behind the For the People Act than they pretend to be. And like, there's some people in gerrymandered districts who like kind of like being in a safe gerrymandered district and are happy to remain in a safe gerrymandered district, even if it's bad for their party. And like, there was a huge blow up a while back because the bill imposes all kinds of requirements on election administrators, and a bunch of election administrators came forward and said, this is too much to ask us to do. And so like, even when you set aside like the big problems, like Joe Manchin isn't fully committed to democracy, there's still a difficult negotiation to be conducted here. And you need, you know, to have almost every member of the Democrats' narrow majority in the House to sign on to it. And you need to have literally every single Democratic senator sign on to it. And if one has like an idiosyncratic concern, I mean, like, I remember when we went through this with the Affordable Care Act, and everyone loves the public option except for Joe Lieberman. So guess what? We're stuck with what Joe Lieberman wants. Like, it's just really hard to pull together a coalition. And I guess the thing I would say to the Democratic Party's leftward critics is that if you're identifying an enemy, please identify the proper enemy. You know, if there are 49 Democratic senators who want a bill to pass and are willing to do whatever it takes to get the bill to pass, your beef isn't with those 49 Democratic senators, it's with the one holdout.
But Joe Manchin, to be fair, does represent a very red state.
Yes.
So he's doing a balancing act there. If Democrats didn't have him to vote on some of the legislation, I think, you know, a Republican could very easily take that seat. He isn't up for a couple of years, I think. But
yeah, no, I agree with that completely. Like, I mean, Joe Manchin is in this, you know, is in the frustrating position of simultaneously being the most annoying person in the Senate and also being better than literally anyone else who could possibly have his seat.
Right. Okay, so back to some broader views here. We have somebody ask, will religious liberty cases expand discrimination of LGBTQ plus and non-Christians?
Yeah, it's going to get bad. I mean, I have a whole chapter about that in here. And this is, I mean, there's a case in front of the court this term. It's called Fulton. And the Fulton case really scares me. So all of the previous cases have dealt with private business owners. Like, so you might remember the Masterpiece Cake Shop case where there was like a private, there's just private individual. He owned a bakery, didn't much like gay people, didn't want to serve cakes to same-sex couples or bake wedding cakes for same-sex couples. And the question in that case was whether he, as a private business owner, was allowed to defy a state law saying that he couldn't discriminate against, he couldn't discriminate on the basis of sexual orientation when he said he had a religious justification for wanting to do so. The Fulton case is different. So the Fulton case involves a government contractor. The issue in this case is that the city of Philadelphia contracts with a bunch of private agencies to help identify foster families and to place children in foster homes. And I mean, identifies with like 36 or so different agencies to do this. One of the contractors that Philadelphia used to work with is Catholic Social Services. And Catholic Social Services, the city learned that Catholic Social Services has a policy where they won't place a child with a same-sex couple. Philadelphia, as part of its contract, again, Catholic Social Service was a government contractor. Part of its contract says that you can't discriminate on the basis of sexual orientation. So the city said, I mean, sorry guys, you're just in breach of contract here. Like it wasn't even a law. It was just you're in breach of contract. And so Philadelphia, the Catholic Social Services sued. And they claim that they have a constitutional right to be able to discriminate against LGBT people and to get a government contract on top of that. And that's extraordinary because like the court has up to this point consistently said that the government has much more authority to run its own operations than it does to tell other people how they can run their businesses. I mean, I think it should be obvious why that's the case. That when you're contracting with the government, you are acting as an agent of the government. And so the government is allowed to say, we do not discriminate against same-sex couples. And if the government wants to say, we will not discriminate against same-sex couples, it can also say, and also the people acting as our agents will not discriminate against same-sex couples. And this case, I mean, I think that Catholic Social Services is going to win. I mean, we're going to get the opinion probably at the end of this month. I think it's very likely to say that even in the government contracting space, if you're religious, you have a right to say, to give both middle fingers to the law and to discriminate if that's what you want to do. And like, that's just extraordinary to me. I mean, again, like it's one thing to say a private business can do what they want in this space. It's another thing altogether to say that my government has to discriminate against gay people because some third party wants to get paid to do it. And yet that's where we are. I mean, the court's handed down a bunch of decisions in the last several months saying that churches get very broad exemptions from COVID-19 public health restrictions. And I mean, I hate to be flip, but like, these are justices who call themselves pro-life. Like, the reason why we don't want people gathering in churches is the same reason we don't want people gathering in movie theaters. It's the same reason we don't want them gathering in like university lecture halls. It's because when you sit together in the same space for hours at a time, and in a church, when you're singing, if one of you has COVID, then a lot of people are going to have COVID pretty soon, and COVID kills people. So like, I was very surprised that the court decided to make cases that were literally about life and death the vehicle that they used in order to significantly expand the rights of religious objectors, but that's what they did. and I think we're going to see another bite taken out of that apple in this Fulton case. I think that the coming battles are, first of all, what other kinds of discrimination they're going to allow. In Hobby Lobby, the court signaled that it will not allow race discrimination, because you have, like, you can't say, like, I think that God wants me to fire all my black workers, so I'm just going to fire them for being black. Like, I don't think the Supreme Court's going to allow that. I don't know what they're going to do about discrimination against religion. If there's an employer, for example, that says that here's something that came up, recently with the vice president, the former vice president, Mike Pence, apparently had a rule that he wouldn't have a one-on-one meeting with a woman. And if you've ever been in a professional setting, when I've been a supervisor before, sometimes I call people into my office and have a one-on-one conversation with them, and they get opportunities that way. A lot of my opportunities that I've gotten, it's because I go out to drinks with one person that I work with, and sometimes that person is a man and sometimes that person is a woman, and so there's obvious gender discrimination implications to having that kind of policy. And I don't know what the court's going to do if someone claims a religious right to discriminate against women. The other thing that I don't know about is that there is a law, it hasn't been interpreted in a very robust way, but there is a law requiring employers to provide religious accommodations to some of their workers. And I worry about a situation where the Supreme Court says that, let's say I'm a middle manager at Walmart, and Walmart, the corporation, is happy to hire gay or trans people. Walmart doesn't care. But let's say I'm a middle manager and I refuse to hire trans people. And I say that my religion forbids me to hire trans people. Does that mean that I can demand a religious accommodation where my employer has to allow me to not hire anyone who's trans as a middle manager? I don't know how that round of litigation is going to play out. But the question is, how grim do I think things are going to get for LGBT discrimination? Grim.
And maybe our last question here in our last couple of minutes and some closing thoughts. We are in a very politicized time. The sources of information that people are ingesting from media is a feedback loop. They're not always hearing other sides. So what can we do? What can individuals do when they feel like the other side, whatever side they're on, they feel like the other side is just falling for superficial arguments and they don't get it? What's wrong with them? What can we do as individuals to try and bridge this divide?
I think it's hard to persuade people. I have never been in a situation where someone tells me something crazy and I say, yeah, that sounds crazy, and they've wound up being persuaded. That's just not how the human brain works. I do think that government can potentially persuade people. We were in a Great Depression. FDR did a really good job of improving a lot of people's lives. And so for 2 generations after that, people wanted people who thought like FDR to be in charge because, there was a proof of concept there. I think that Joe Biden is playing his cards as well as he can. Who knows if Manchin's going to let him pass an infrastructure bill, but passing a big COVID relief bill, that's exactly what he should have done. Convince people that you're going to make their lives better if you want to change their mind. And then the burden on all of us, and this is a burden that's going to fall unequally. So I live in Virginia. Virginia, is probably going to stay a blue state. The legislature just passed, a very good law, making it very easy to vote in the state of Virginia. So when I go to vote in the next election, I will just walk over to the polling place and I will cast my ballot, and it'll be easy and it'll be fine. If you live in, say, Atlanta, the most troubling provision of the Georgia voter suppression law is a provision that allows the state Republican Party to essentially take over local election boards and then shut down polling precincts, disqualify voters, just do all kinds of crazy stuff. So if I am a voter in Atlanta, there's a good chance that the Republican Party is going to take over the local election board and then try to shut down a bunch of precincts, specifically in Black neighborhoods. And the voter suppression bill also says that volunteers aren't allowed to bring people waiting in line a bottle of water. So these voters might have to wait 6 hours without anyone being able to bring them a bottle of water in order to cast their vote. And like, there's nothing fair about this. And like, the people who are going to carry the burden of this law, for the most part, are not going to be people who look like me. And the only way to overcome that law is that every single one of those people has to decide, I am going to wait in this line regardless. And if no one can bring me a bottle of water, I am going to bring my own damn bottle of water with me, because I am not letting this state take away my right to vote. And like, ultimately, like, that's the most important thing that all of us can do is like, most of these laws, like even the really bad laws, they don't disenfranchise people in their entirety. They just make it harder. And if someone puts a hurdle in your way, you got to jump over it. If they put a fence in your way, you got to climb over it. Because like, what the people who are passing these laws are counting on, and what the Supreme Court is counting on when it upholds these laws, is that people can be deterred. And if they can't be deterred, then like, we will continue to have presidents who want to appoint justices who aren't like Gorsuch or Kavanaugh or Barrett. And we will continue to have a Senate that will confirm those justices. And eventually the problem fixes itself. Clarence Thomas isn't going to live forever. But it requires a sustained effort, and it requires hardship that will not fall equally on all Americans.
All right. Well, thank you so much for tonight. This was a really lively discussion. We had a lot of questions coming in. I hope everyone enjoyed it. We recorded the event, so we'll be sharing that tomorrow. If you have any other information you want to share with everyone, just let us know. We can send that out. Of course, everyone
buy the book.
We sent some links. I'll make sure to share that link again. You can get it on Amazon like tomorrow. So go order it now. And thank you everyone so much.
Thank you.